Fair justice is a basic and fundamental principle of any democratic state, which Ukraine has been during various periods of its history, dating back to its 1,000-year history of law. And today, Ukraine's highest judicial body, the Supreme Court of Ukraine, is in the spotlight.
До Верховного Суду України.
Here we find ourselves in the governmental quarter with the presidential administration, cabinet of ministers of Ukraine, and the Верховна Рада in close proximity. The Supreme Court building, otherwise known as the Clove Palace, is situated at 8 Pilipa-Orlika Street. The building is easily accessible. There is a skybus shuttle service to Kharkivska metro station for those traveling from Boryspil airport. Those en route from the central bus terminal can take the metro at Demiyivska station, and those coming from the central railway station will find the Vokzalna metro station adjacent. Whichever route you choose, get off the metro at Krishchatik metro station and follow the signs to the Institutska Street exit. Then walk along Institutska Street until you find yourself at Lipsky Boulevard. Enjoy the greenery in Kiev while walking along the boulevard until you reach the Clove Palace, an 18th century Baroque architectural pearl and the seat and daily office of the Supreme Court of Ukraine. The Clove Palace is open to the public. Guided tours are available to anyone, but prior application is required. The palace has many things to offer. You can visit the Museum of the Supreme Court of Ukraine, as well as attend a court meeting, and even meet the President of the Supreme Court. And with that in mind, we'll make the most of our visit today, starting with the museum and a historical outlook. I did not mention Ukraine's 1,000-year history of law for nothing. This clay disc inscribed with the name of a candidate refers to an ancient ballot used by Pontic Greek colonies during their elections. These clay discs, or ostraka, stand as evidence of the electoral freedom that existed in the territory of modern Ukraine during the Classical Age. Ruska Pravda, issued by Yaroslav the Wise during the times of Kiev Rus, was Ukraine's foundational legal code. The provisions of the code not only governed ancient Ukrainians' rights to life, freedom, and property, but also provided judges with a document with which to decide cases. Every level of court, including the High Court, known as Royal or Kняжий Court, judged cases by this same standard. The Ruska Pravda was very progressive for its time, and it was used by Lithuania as a foundation in passing its own code, which remained in force in many Ukrainian territories until the very beginning of the 18th century. The constitution drafted by Pilipa-Orlik is especially important with its provisions for the delegation of legislative powers to the General Council. It is very fitting that a monument to the main writer of Ukraine's first constitution be erected opposite the Supreme Court building as a symbol of his advocating for independent and free Ukraine. As an independent state, Ukraine created its justice system after it proclaimed its independence as the Ukrainian National Republic back in 1917. Serhiy Sheluhin was a world-renowned scientist, Minister of Law and Justice, Senator of the Ukrainian state, the Hetmanate, and the first chief judge as well as a chief state prosecutor of Ukraine. He created much of the judicial system we now use in Ukraine. Why and how did it all happen? With Ukraine's proclamation of independence in 1991, it was necessary to establish a system that was drastically different from the Soviet court, where a vast number of issues were resolved by means of phone calls. The new provisions were based on the laws established during the times of Khrushchevsky and Skoropadsky during the period of Ukrainian War for Independence in 1917. In 1993, Ukrainian judges returned to wearing judicial robes after a long break. The court gown has truly symbolized the return to the traditionally established European law procedure by which Ukraine continues to abide. The President of the Supreme Court governs the court's activities and exercises the powers and duties vested in the office.
Доброго дня, Ярослав. Дякую.
насамперед я є суддею. Не будучи суддею, я не міг.
First and foremost, I'm a judge. I also happen to occupy the presidential post of the court. I do this in addition to my judicial duties, so while I perform some administrative duties, I also consider legal cases just as any other judge would. As far as the powers of the President of the Supreme Court in the administrative capacity are concerned, the President primarily has the authority to represent the Supreme Court as the body of state power, as well as the entire judicial system in relations with other governmental authorities, individuals and legal entities, as well as the international organizations. Within my terms of reference, I'm entitled to convene the plenary assembly of the Supreme Court and chair the plenary assembly. I'm also entrusted to make a submission regarding the appointment of the plenary assembly secretary and the secretaries of judicial chamber for plenary assembly's considerations. Within empowered duties, I shall also exercise control of the efficiency of activities of the staff of the Supreme Court, as member of staff are those providing efficient operations of the court as legal entity.
The Plenary Assembly of the Supreme Court of Ukraine is a collegial body composed of all the judges of the Supreme Court of Ukraine, particularly with the right to appoint and remove the President of the Supreme Court and his deputies from office, as well as to appoint the Secretary of the Plenary Assembly and Secretaries of the Judicial Chambers from among judges of the Supreme Court and, upon a motion, by the President of the Supreme Court. The Plenary Assembly also hears information on court activities provided by the President of the Supreme Court, states findings and conclusions on draft legislation regarding the judicial system, court system, and the status of judges, etc. Renders decisions on recourse to the Constitutional Court of Ukraine made regarding any matter related to any constitutional laws and other legal acts, as well as the authoritative interpretation of the Constitution and laws of Ukraine.
The Supreme Court of Ukraine is always involved in lawmaking process. Our authorities includes providing legal options regarding bills on the status of judges and functioning of the judicial system in general. In each legal option, we always refer to international standards. In particular, we refer to the documents issued by the Community of Ministers of the Council of Europe, decisions of the European Court of Human Rights, opinions of the Venice Commission, opinions of the Consultative Council of European Judges. Notwithstanding our standards or objections to a certain legalistic initiative, we rely on international standards as grounded for such an option. This is an everyday and ongoing job that we do. We know these standards and always adhere to them as primary guidance in our work.
Welcome to the courtroom, where court hearings take place. Here, the Supreme Court of Ukraine administers justice within the order prescribed by the procedural law and reviews criminal, civil, administrative, and commercial law cases rendered by the superior courts in particular. The court is open to the public, but a visit is subject to prior registration. In the general jurisdiction courts, the basic principles of territoriality, specialization, and instant hierarchy apply as prescribed by the Constitution of Ukraine. Once a case has been ruled on by the city or district courts, it may then be appealed. Should a cassation be filed, the case will then be transferred to Kiev, where the superior courts, which consider cassation appeals, are. After the judgment is reviewed following the established legal procedure at the Court of Cassation, the parties and the other participants in a lawsuit or legal proceedings can request a retrial directly at the Supreme Court of Ukraine. Depending on the specific nature of the case, appeals shall be considered by the one of 4 judicial chambers within the Supreme Court of Ukraine. Judicial Chamber on administrative cases, Judicial Chamber on commercial cases, Judicial Chamber on criminal cases, Judicial Chamber on civil cases. Each judicial chamber of the Supreme Court of Ukraine is headed by the secretary of the respective judicial chamber. We'll start with the judicial chamber in charge of criminal cases. The name of the chamber speaks for itself. Our daily operations are to review the criminal judgments. Not all judgments, however, fall within the scope of our chamber's consideration, but include those with legal grounds and only acting in the matter prescribed by the law. For instance, now citizens representing the injured party may have recourse to the Supreme Court personally. So they may do with recourse to our chamber, filing a submission to review the judgment. With that in mind, it makes daily operations more difficult for the chamber in one respect, due to a large number of cases and submissions filed. However, in another respect, it gives judges of the Supreme Court an opportunity to define on their own upon the issues or case category to be reviewed and considered. Should the nature of the legal dispute be the protection of rights, freedoms, and interests of individuals, or the rights and interests of legal entities within the scope of a public relationship, the case will be referred to the Administrative Judicial Chamber.
В адміністративних справах.
The Chamber of Administrative Case considers the largest amount of cases at the Supreme Court of Ukraine. Because there are so many social disputes in the state, many people challenge the established pension amount and appeal decisions to administrative judges for us to review the case. There are a vast number of dissatisfied tax payers who appeal the decisions rendered by tax authorities also in cases pending the issues of the conduct customs authorities and being raised. And in all those cases, the rules of substantive and procedural law are applied differently. Those the cases are submitted to the Supreme Court of Ukraine for the Judicial Chamber of Administrative Cases to review them. Also, there's one more case category, which falls beyond other judicial chambers, which is the appeals against actions, disactions, and inactivity of the High Council of Justice, the Верховна Рада of Ukraine, and President of Ukraine. Collectively, it puts a lot of pressure on judges of the judicial chamber on administrative cases.
If the dispute is between individuals, it will be referred to the Judicial Chamber on civil cases. This chamber deals with the protection of rights, freedoms, or interests among individuals. Cases range from finding agreements invalid, to enforcement of rules of the family code, to the division of jurisdiction of certain case categories. The analysis of the statistical data allows the Judicial Chamber to define the number of those case categories under review. Taking into account that I perform press judge duties on top of my regular work, I inform the media at open briefings about the case categories under review and those pending. Specifically, I recently referred to finding respective mortgage agreements invalid on the grounds of children's rights violations. Since the rules of the family code were applied differently depending on the court in such cases, the Supreme Court created a guide to applying the family code, thereby helping the code to be applied more consistently. Last but not least, there is the Judicial Chamber on commercial cases, which has power to review judgments regarding commercial cases when enterprises, institutions, organizations, and other legal entities, including international ones, as well as individual business owners, are involved.
Abiding by the rules of the Commercial Procedural Code of Ukraine, we consider cases and, what is crucially important, creating guidance for other courts to follow. At the court, decisions are binding on all parties to a legal relationship. Consistent application of the rules for the substantive and procedural law, issuing options and finding that the Supreme Court of the various topics and consideration of issued rights within the European Court decisions. Those case categories are subject to the further revision at the Supreme Court of Ukraine. As the rule, parties represented in our chamber are business entities, and with that in mind, their rights are represented by qualified, experienced, and well-educated lawyers. Here, one should mention a specific nature of submissions, since high-qualified lawyers lodge submissions and have recourse to the Supreme Court rather than a citizen, as this is the case in criminal and civil cases.
Media representatives and activists from non-governmental organizations frequently attend and contribute to the events initiated by the Supreme Court. Media conferences and briefings are a platform for Supreme Court senior officials and judicial speakers to make known to the journalists the daily operations aimed at abiding commitment to the rule of law. A number of joint international events involving foreign experts, prominent national figures in science and law, activists of civil society are to study the best practices and discuss opportunities for implementing international standards of justice into the national system. The Supreme Court of Ukraine both proclaims the unity of judicial practice and makes proactive efforts to implement the highest international standards of judicial procedure.
Як бачите, Верховний
The
Суд
Supreme Court of
України
Ukraine
відкритий
is an
суд,
open institution,
який
always
завжди
prepared to take the requisite steps toward establishing justice.
Адже саме справедливість по
Indeed,
відношенню до
the fairness for
кожного
all
безвинного
principle has been a key element of a democratic state.
держави.